Hello, and welcome to the Basics of the Cloud, presented to you by the American Bar Association, Law Practice Division's Legal Technology Resource Center. I'm going to talk to you today. I'm Dan Sigel. I'm an attorney from the Philadelphia area about the basics of the cloud. So we're going to take you on a quick tour of the cloud, what it is, and how you can use it ethically in your practice as well. So what is the cloud? The cloud is quite simply storing stuff anywhere but on your computer or in your building. So when you used to have AOL and the disks that you would store information somewhere else, that's the cloud. Your smartphones can't store all the information you want on the phones. So where is it? In the cloud. It simply means on a computer, a server somewhere else other than where you are. You won't be able to touch it, but it's there. It's not really up in the clouds. There are many ways that you can have cloud services, and we're not going to get into the details of them generally, except that you should know that there are three main methods of having cloud services. One is infrastructure as a service, one is platform as a service, and one is software as a service. Probably if you're going to need it, the vendor will explain to you. Infrastructure is sold on demand, and it is literally a replacement of your infrastructure in terms of your equipment. Platform as a service allows you to use the cloud for as many types of items as you want, etc. And software as a service is you're using the cloud company or entity's software, and they manage everything. Back in 2010, Quinn Norton, who was a columnist from Maximum PC magazine, wrote that cloud computing is a fancy way of simply saying stuff's not on your computer, but your computer is the way that you get your stuff, and it's the interface. It's not where the magic happens. But she noted there's a catch. When your stuff is in the cloud, it isn't covered by the same laws about privacy or access by law enforcement than when it's in your own house or on your own computer. I'm in Pennsylvania. I'm covered by Pennsylvania and US federal law. But if your stuff is stored on a computer in India, what are the laws that cover that? And as Quinn Norton indicated, what's worse or could be worse is that your use and access of your data in the cloud is based on those terms of service. And those terms of service are usually the box that you click and just check and say, I agree. But when you're dealing with client files, you can't just do that because the terms of service may say that you don't even own the data. Well, your client files are your clients, so you don't own the data, but your clients do, and you can't agree to simply give that option away. And depending on the company, you have to understand that they may or may not let you know how your data is being stored, audited, secure, et cetera. And this quote from 2010 at a trial, Adam Swidler, the Google then product marketing manager, said, we're not going to let you audit, and you're going to have to trust us. Well, the good thing is that since 2010, a lot of companies are providing much more information and access and auditability than they were in 2010, but you still have to be nervous. Google's terms of service, for example, is lengthy, and it tells you everything from what you can expect from them, what they expect from you, and what happens to the content, your materials in their service. Because Google, despite its perception, is not a search engine company. It is, in fact, a marketing advertising company. That's where they make the bulk of their revenue. Similarly, Apple, the iCloud terms of service, that also is governed specifically by their terms of service and tells you everything, including, as Quinn Norton said, whether they have the right to access and own your firstborn child. But the reality is, whether you're storing information on your server in your office, on your PC, or somewhere in the cloud, stuff happens, and you have to be prepared for those ethical, legal, and practical concerns. You can't simply say, as this kid did in a New Yorker cartoon, that the cloud ate my homework. That won't pass. I once worked with and represented a client, a law firm, that had information stored in the cloud, didn't have access to the information or the backups because the provider had financial problems. They were storing on the cloud extensive files relating to a multi-million-dollar real estate transactions, and they did not have backups in their office. As a result, there were concerns, and they almost didn't go through with closing. Other concerns are, as I mentioned before, if your data is stored in India, what are the protections there? Who does it say own the data? And has the data been backed up? What are the provider's policies for data breach notices? Is there appropriate encryption, which simply means storing it so that someone who tries to access your data can't see it or use it without the password? And what are their data destruction policies? Because if you terminate that contract and don't use them anymore, what happens to your data? Other concerns, of course, are what happens if the provider goes bankrupt, or you change providers, or you're hacked, or your provider is hacked. Those are all practical considerations that you need to think about, because often it's not the law firm or the lawyer that's hacked, it's the cloud vendor, and you need to be prepared for that. One of the things you can do, which I'm not going to get into detail here, but put in the thought in your mind, is to obtain cyber insurance. You have ethical concerns with data stored on your own premises, and that's one of the reasons the cloud is so good for backup. You can have your server crash, or a virus, or there could be a hurricane, or God knows what, or any other kind of disaster. And if you haven't made plans to deal with that, then you're going to have a problem. That's why best practices is store your data both on site and in the cloud. Some data shouldn't be in the cloud. It's just too important. Like the Thomas's Nooks and Crannies recipe, the recipe for Coke Classic, and of course, Colonel Sanders' top secret recipe as well. Things like that you have to discuss with your clients so they understand whether or where you're going to store certain data. Cloud computing reduces overhead in many instances. You have to price it to see, but it can also increase your productivity because of collaborative tools like Google Docs. We learned just how valuable cloud computing and access in a collaborative way can be during the pandemic, because most of us could not go to our physical offices for quite some time. And as a result, if the data weren't either stored in the cloud or some accessible location, there were problems. You can't just contract with any vendor. You have to make certain that their policies are appropriate. But with reasonable precautions, cloud computing can and may be your preferred way of accessing software and storing client and firm data. One of the reasons is clouds are encrypted. When you see that S or the little padlock symbol on your browser, you know that that site is encrypted and secure. On the other hand, is your office server, is your office computer, are they encrypted? Are they secure from hackers? And in most cases, these companies that encrypt and host your data are much larger than your firm and have the financial and technological capability that you don't have on a typical office. The cloud has advantages. It may be more cost effective. It can improve your work product. Certainly, if you couldn't share data during the pandemic, your work product was certainly diminished. It can automate your tasks, and you should be connected essentially 24/7. Other advantages are it can save you money because you're not dealing with infrastructure, updating all of your servers and all of your desktops as frequently. You can easily track the costs. It offers immediate access for updates. Usually the vendors do it. And in most cases, the software security is better or comparable to a law firm's, but rarely is it less secure, so that your office focuses on what you're doing rather than managing technology. When you use the cloud for backup, you have disaster recovery. You don't have to deal with tape or other backup systems. Your costs are predictable because you know what the vendor is going to charge. You can get data recovery. Typically, they'll send you a new hard drive that you can load. So in my office, we're in an old house. If the building burns down, my cloud backup vendor can simply send me a new hard drive with an image of all of my data. I can install it in a new location and my server should be up and running. And a well-managed cloud is more secure than that of most firms. So how do you use the cloud ethically and safely? One is you read the rules of professional conduct for your state or any states where your firm practices. They will give you a lot of guidance. They are based on the American Bar Association model rules. However, each state may make revisions to them, so you need to be aware of the rules specific to your state or states in which you practice. In addition, many state bar associations have ethics committees that offer guidance in nature of formal or informal ethics opinions. You should read those, including the ones related to your state. But in the area of cloud computing, there are a lot that are well beyond just your own state that will provide a lot of guidance. You need to understand the risks, just as you would tell your clients to understand the risks of anything they do, and be careful. Using the cloud implicates the rules of professional conduct, and as I mentioned, many ethics and professional guidance committees have authored opinions about that. Most say, if not all, in fact, that it is permissible to store data in the cloud, but you must use reasonable care and take reasonable precautions. And at the same point, you have to understand the difference between the cloud on-site and other storages systems. You also need to involve your IT department, because they're the people who know. We didn't go to law school to be computer and technology and internet security and cloud experts. That's why you hire consultants for those areas who can help you. Similarly, what do? Not only do you read the guidance for each state, but you should apply the most stringent recommendations out there for your own state. Opinions of other states can be helpful. The Pennsylvania Bar Association Committee on Legal Ethics, we issued an opinion, I'm chair of the committee now, in 2011 that was considered and is still considered the leading opinion in the country about the ethical concerns. Iowa's Ethics Committee issued a superb guidance opinion that literally provides a checklist that is still applicable today of what to do. So those are out there for you, but your ethical considerations don't change. Under terminology, you have to understand that you have to be competent. And competence under Rule 1.1 means understanding the risks and benefits associated with technology. Rule 1.4 talks about communication and making certain that your communication is secure. Similarly, because you're storing data, whether it's on your property or in the cloud, you have to make reasonable care to assure that the data are confidential. And you have to safe keep the property because that data is or may be your client's property. And under Rule 1.15, traditionally thought of as the IOLTA rule, you have an obligation for safekeeping of property, not just the money in your IOLTA accounts. And finally, Rule 5.3 talks about your duty relating to non-lawyer assistance, NTS, not NCE. Those are and could include your IT vendors and others who work for you to assure that your technology is secure. Most states agree, and no one I think would disagree, that we all have as attorneys an ethical duty to protect sensitive data. And you have to understand then, or have a reasonable basis to know how your providers are going to handle the data that you give them. And if you don't understand, then you may need to bring in a consultant or someone else to review that information because you are obligated to protect it. And you need to include and review the terms of service with the provider, because they must agree to preserve the confidentiality and security of the data. There are a lot of other suggested terms that you want in those agreements. You can see more information about them in the state ethics committees. So how do you use the cloud safely and ethically? First, you read the rules, you read the guidance opinions, you understand the risks, and you need to be careful. And of course, you need a disaster recovery program or plan now, not at the end of the day after it happens, but in advance to plan for what happens if there is a disaster on site, in the cloud, wherever. I have just taken you on a brief tour of the basics of the cloud and the ethical considerations related to them. I'm attorney Dan Sigel. I thank you for joining me for this presentation for the American Bar Association Law Practice Division Legal Technology Resource Center. Thank you very much and enjoy the rest of your day.